All right, I think we are all set up. I am out here for Hutter and Associates versus Hyde Brewing and Market District Crabapple. Hyde Brewing has filed a motion for summary judgment as to all of Hutter's claims which relate to a construction contract and work that Hutter did. Market is sort of in the mix only because of the lien that Hutter's put on there. So I don't know. I do see Mr. Slomka. He's here, but may be quiet during this process. We'll see. And someone just filed a brief this morning. That's kind of hard for us to process, but you'll be able to talk about it. Don't assume that anyone has read it other than you.
I don't think so.
Okay.
On record.
All right. Well, let's figure out who's here. Who is here for Hutter?
David Johnson for Hutter, Your Honor.
Hey, Mr. Johnson, I'll put you big on the screen there so people here can see you. And here for Hyde.
John Rick Drager.
Good morning, Mr. Drager. And Mr. Slomka, you are here in the just in case category for Market District Crabapple.
Well said, Your Honor.
All right. Appreciate you being here. And there are other folks here. If they want to sit up at council table, that's fine. They may just be spectating, but however they want to do that. Let me summarize what I understand the situation to be here, only because if I happen to be partially right on that, it'll save everyone some time. You won't need to cover extra ground getting me up to speed. And then we will let the lawyers do their thing. Okay, so as I understand it, Mr. Drager, your client rents space from Mr. Slomka's client and operates a brewery or whatever Hyde Brewing does. And Mr. Johnson's client did a bunch of work to make that space more habitable or in the Hyde Brewing style or whatever. It was a construction contract. Hutter claims it wasn't fully paid. I think they are saying it's around $360,000 that's still owed. They've sued for breach of contract, quantum meruit. There's this lien on there. You've counterclaimed for negligent construction. Everyone always wants lawyers' fees. You filed, Mr. Drager, a motion for summary judgment that basically says there's no contract here. There was an agreement to agree because I think it's paragraph 2 sets out the $900 and something thousand of the contract, but there are subsequent paragraphs, or at least one, that said, yeah, but that's an estimate. Who knows what the real number is going to be? And so really there just are some signatures on a document that outlines what an agreement might be, but it is not sufficiently definite, in particular on the critical term of price, to be something that could support a claim for breach of contract. You can't breach a contract that doesn't exist. On the quantum meruit side, I think you concede, you don't necessarily have to have a contract, but there's just still not enough concreteness to what the services rendered that haven't been paid for to support the complaint. And I'm simplifying it, and I'll let you be more sophisticated about it. But I think that's sort of the thrust of your argument. And then Mr. Johnson pushes back by saying, this is a pretty standard construction contract. Look at the plans, look at these other things. He thinks the contract is sufficient through its four corners, but also you really, when it comes to enforcing it, you look at where are the parties at the time there is an effort to enforce it, i.e. this litigation. And by now payments have been made, all with an eye towards, look, the total amount's going to be the $953,000, whatever it is. So he's pointing to other indicia that would indicate that as of the time of the litigation, there was a clear agreement, not just an agreement to agree. I'm gonna let you guys argue which is the better position, but that's sort of where I think we are. Anything more we need to cover before you dive in procedurally?
Pretty good summary, Judge.
Okay, Mr. Johnson, before Mr. Drager starts, anything you want to correct? There's just this one critical piece you need to better understand.
No, I think that was fine, Your Honor.
Okay, great. I mean, I didn't need the pat on the back. I just wanted to make sure I wasn't missing anything. All right, let me.
Part of my outline, but, you know.
Yeah, there you go. Would you mind, Mr. Drager, if you'll move that screen a little bit? You can stand wherever you want. I just need Mr. Johnson to be able to see you. So there you go. Okay, that's plenty good. And then perfect. All right. Good morning.
Morning, Judge. May it please the court. You summarized the contract situation pretty much. A little background facts. You know, the party got sideways about 90% into the job. And there were 5 previous pay apps that were paid without question. We got this last pay app, which is about 40% of what the other 5 previous payouts were. When 90% of the job was done, that's when things got sideways.
Were the 5 previous payouts about 1/6 of the 950,000, or they were varying amounts?
I mean, the payouts, the work was done, the payout was submitted as the work was being progressed, and it's about 90% done by the time it's all kind of.
Okay, so let me ask it a different way. So when we were 90% done, was it about 90% of the 950,000 that had been paid out?
No.
Or the last amount was when you put in the gold chandelier and that was going to be 400,000, and so there was a big amount that still hadn't been paid?
It was 90% done. We paid through payout 5. We paid 90% for that work.
Yeah.
5th payout comes along and they hit us with it's called general conditions, $170,000, various things that we don't believe are actually part of this deal.
Okay.
And that's when.
So you're saying this is after the 5th payout, or that's the 5th payout where people start?
6th payout is when things got crazy.
Got it. And there are things added that your client doesn't think should be added. But leading up to that, all the payouts had been made, no issues, et cetera.
Right.
So when the 5th payout was made, you're saying work was about 90% done?
Yes, sir.
Okay. And so had your client paid about 90% of $950,000?
No, because we dispute that number.
I thought that's what was in the contract.
That's what the contract says.
Yeah.
I think that's the whole issue here, Jeff.
No, I understand. But I'm just looking into, are there indicia that 950,000 actually was an agreement and everyone was trending towards it? By the time the 5th payout was made, ballpark, how much had been paid out?
I want to say 600,000.
Okay, so you were only 2/3 of the way into that figure.
That's that 900,000.
Yeah, insofar as that figure is interesting or controlling or anything like that, payout 5, which was 5 of 6, was only 2/3 of the way down that road. Yet you were 90% of the way through all the work.
Correct.
Okay, all right, thank you.
Judge, the primary question for you is whether or not this is a contract. And as you summarize, price is an essential term in any contract. Without that, you don't have a contract. If there's an agreement to agree, as you said, it's not a contract. As you point out, paragraph, copy of this contract here, Judge, you want to look at it?
I think I have it
Many
in,
times.
let me look in my magic folders here. What would it be under? I've got, is it part of the answer or the complaint?
It's attached to the complaint.
Complaint, let me pull up the complaint. That'll do it. Okay, there's the contract.
So, paragraph 2, Judge. It says, sets the contract sum, it says $953,981 and no cents.
That seems pretty certain. I mean, that's down to $1.
Yep.
Okay,
Then you get to paragraph 12.
okay,
Owner and contractor agree that the contract sum in paragraph 2 is only an estimate and will vary based on the actual work performed at the site by contractor in accordance with written instructions from Hyde during the construction process.
I'm curious, this is total side. I just got off a scheduling teleconference in a case about Jekyll Brewing, and Joshua Rachel is a defendant in that case. That's Is Joshua Rachel would be the owner of Hyde Brewing, so your client. Did he also do Jekyll Brewing?
I don't know anything about Jekyll Brewing.
Okay.
I know Joshua Rachel he's not an owner. He's one of the principals. And
Okay.
If I may, Your Honor.
Yes, please.
He is involved in both ventures. He's not
He was involved in Jekyll. Jekyll is,
he was involved in Jekyll and he's involved in Hyde, where he's not an owner, but he's
okay.
yeah. So
Jekyll owes Synovus Bank about $3 million, but that's a different case,
right.
which we were just talking about. Small world, Mr. Rachel's all over it. Okay.
just so you know, I'm saying, there are two owners of the company. Mr. Rachel's not one of them.
Okay. All right.
Anyway,
Okay, so paragraph 12, I just saw Josh Rachel's name, and like, I was just talking about this guy, into the brewery business. Paragraph 12.
again, I can read it again, but it speaks for itself. It says the contract sum in paragraph 2 is only an estimate and will vary based on the actual work performed at the site by the contractor in accordance with the written instructions from Hyde during the construction process. Now, Judge, the one thing in your summary that I think Mr. Johnson was saying that I very much disagree with is if a contract doesn't have a firm price from the four corners of the document, and the case law is very clear, you cannot resurrect it with what happened afterward. And that's what they're trying to do here. So the question before you is it clear from this contract that the parties had an estimate only of the price and not come to a firm agreement on the price, and therefore the contract is DOA and you cannot resurrect it based on what he says happened down months after the transaction. And there's several cases in my briefs that discuss this, where it's evident from a written instrument that the parties contemplated where it is evident from a written instrument that the parties contemplated that it was incomplete and a binding agreement would be made subsequently, there is no agreement. There's the Hewitt Associates case, the Colmatic refrigeration case. An agreement to reach an agreement is a contradiction in terms and imposes no obligation on the parties thereto. To be a final agreement, the parties must comprise all the terms which the parties intend to introduce into it. Where it is evident from the written instrument that the parties contemplated that it was incomplete, that a binding agreement would not be made that a binding agreement would be made subsequently, there is no agreement. Now, first, I want to just go over the contract itself, Judge. You got paragraph 2, paragraph 12, which clearly says paragraph 2 is just an estimate. As part of was incorporated into the contract were the bid notes, and I've got copies of those as well.
They're incorporated into the contract?
Yes, sir. Right
Where
there.
does it say that?
Paragraph 1 reads, contract specifically noted that scope of work is based on construction documents, the proposal dated 8/18/23, and the bid notes and clarifications dated 8/17/2023.
Okay.
The bid notes in Article 3, I believe, read as follows.
Are they part of the complaint also?
No,
Bid notes?
he didn't attach to the complaint.
Okay.
They're in the record. I've got copies here if you'd like to see them.
They're in the record through what? Where?
Let me cite my brief.
Now, I have your brief. Are they attached to your brief?
No, I think they're cited to maybe Mr. Rachel's affidavit. They're
I've got affidavits.
If I could, I think they're in Exhibit 1 to Mr. DePaula's deposition.
Okay, thank you. Bunch of invoices. I don't know what a bid note looks like. Will it say bid note on it?
Yeah, very top, it says bid notes and clarifications.
Okay. Well, keep going.
Well, under section 3 of the bid notes, this is addition to the paragraph 12. Section 3, page 5 of the bid note says, this is an estimate of cost of construction, and upon receipt of the final design documents, adjustments will be made accordingly. And then there are 3 other places in the bid notes where they talk about these are estimates. So, Your Honor, there's the contract, the bid notes are part of the contract, clearly stating that, again, these are estimated numbers. The evidence is that the plans weren't finished by the date the contract was signed, and there were other issues between the parties that were still outgoing regarding the terms of the contract. Tile in an office, location of an AC unit, various matters just weren't done when these parties signed this contract. And this is, I don't know about you, but I've never seen contract language in a contract like paragraph 12 before that totally says the number on paragraph 2 is just.
That was going to be one of my questions. You've been in this line of work for a while. On its face, this looks like a fairly standard contract. It's not written in crayon or anything. It's all typed up and everything. But paragraph 12 is that's a surprise for you.
I still remember the night I was reading the contract and I saw that paragraph 12 and I said, yikes. Yeah, I've never seen that in a contract.
Okay.
In fact, in the depositions, I asked their 30B6 representative on negotiations about who drafted this contract. Apparently it was drafted by their attorney. Is that? Oh. I'm sorry, I thought I turned it off. I'll get it here. Oh, excuse me, Judge, I thought I turned it on.
It's okay.
Yeah, so well, I was taking deposition of Mr. Robledo, who is the Vice President of Construction for Hyde, designated as a 30B1 rep on the issue of negotiations and drafting the contract. I asked him, he says that they've used this probably 5 or 6 times. I asked him for, when. He couldn't identify a single job. I mean, these folks do several jobs a year, many jobs a year, and they use what everybody else uses in the business, which is an AIA contract. This thing was drafted apparently by their attorney some time back. And in fact, in this job, they were going to use the AIA form, and somehow they ended up with this form. But yeah, this is a totally unique, and it's not just, it's not a gotcha, Judge. I don't know these facts, but these guys didn't have a contract. That was the whole, these negotiations started in April of 2023, and now we're in August, and they're still going back and forth. And everybody wants to get going, but nobody has a contract, has a number yet. And so they signed this contract. It's crazy. It clearly says they haven't come to a firm agreement on price.
What would this look like if it was you call it an AIA contract? There'd be a price, but presumably there's language in there saying, I guess that's what change orders are all about. Hey, we Hyde are agreeing to do this work for Hyde Brewing for $953,000. We agree that's the price, but there's language in there that says, that could change.
That's not, at least not a contract I've ever seen, Judge. A change order comes about. If you have a change, you have a change, and you sign a change order.
Right. That's my question, is that the pressure release valve in a construction contract, because we know nothing is ever built for the original price. And I don't know that anyone would shy away from calling that original price being an estimate. But people agree, hey, our contractual commitment is we'll make these improvements for Hyde Brewing for $953,000. But there's language in the contract that could allow that to go up if there's I guess it's a change order.
This actually, Judge, this contract does call for change orders.
I see that. That's the way in which
Go up and down.
that's the way in which a price that's agreed upon in advance with no crystal ball can be adjusted, because tariffs kick in. Who knew steel was going to be 50% more expensive? Well, tomorrow it's not, but today it is. That's where a change order could come in, so that there is some give in that negotiated price. Not a paragraph 12, but it's here paragraph 4. That's the way you build flexibility into a construction contract.
There's 2 ways. Change orders, I think, more of if, I wanted a staircase, I took the staircase out, we reduce the contract.
Oh, where the customer says, hey, I wanted a staircase, now I want an escalator. Well, that's going to cost you more. Okay.
Take the staircase out, in which
Yep.
case it costs you less.
Yep.
I mean, that's what changes are all about.
Okay.
I mean, and on your issue of tariffs and price of steel, you can build into contract that, should costs go up, we will, charge X%, of the, whatever the costs are.
Got it. But there's language in there that addresses that contingency.
Yes, sir.
As opposed to language that said, this number is just an estimate. I don't really know what it's going to be in the end.
Correct.
Okay.
And so that's our position, Judge. I think the contract's clear. It's just an estimate. The party said over and over again as an estimate. And we're going to get back to this issue of, can they present post-contract actions to clarify the contract?
Right.
And the law is pretty clear on that when there's an ambiguity or an uncertainty in the contract, then you can bring in.
Excuse me, I hate to interrupt. I just got a message on my computer that our IT people are doing something and it's going to reboot my device. Can I have 2 minutes to see what that's about?
Sure. We'll pause.
I have no idea what's going on with that, but
Okay. Thought he was going to turn into a cat. Stop moving your microphone. It makes that bad noise.
Did I do that?
We're off,
No, you didn't.
we're off the record, correct?
We don't have a record. So, yep, we were never on.
When, Your Honor, when you said that you saw Mr. Rachel's name again, and you were surprised, I was thinking the same about yours. It was on that case, and I said, this guy again.
I do not know what is going on here, but I'm going to, if I get kicked off, I will sign back in.
Okay.
I
And
apologize. I don't know what the heck is going on or why there would be an issue.
Okay.
And maybe there won't be.
well, we will pause if you disappear, and we'll wait for a few minutes. If you don't reappear, that's on you, but we will assume you're doing your best to reappear.
I certainly will.
Okay. All right. So, Mr. Drager, you were about to address some of the argument that we both expect that we'll hear from Mr. Johnson about, well, you can look at how the parties behaved post-contract, if there was something vague in the contract, to see if that removes the ambiguity.
Yes, Your Honor.
Okay.
The rule is, if the parties do not create a complete binding agreement, the courts are powerless to do it for them or order for a remedy for the breach. Counsel cites several cases, things, the Chile case and the Arrow case, talk about there's an uncertainty. You can bring in a post-contract actions. So he has to show you where the uncertainty is, and there's not an uncertainty here, Judge. He makes, I think, 4 arguments as to why it's uncertain. The first one, he says, well, he gives us alternate definitions for the word estimate. And, I think some of those alternate definitions say price. Again, your job is to read the 4 corners of plain meaning of the contract. None of his definitions make sense in paragraph 12. It's only an estimate, and the price it's only an estimate and will vary based on the actual work performed. There's no ambiguity as far as the word estimate as used in that sentence. Next, I think he addresses the bid notes, where I had pointed out the bid notes, again, state they're only an estimate. I believe he submits an affidavit of Mr. Westhutter, who's the project manager on the job, who says, he states in his affidavit, the parties never intend to be just an estimate. That's what he says in his affidavit. 30B6.
Would he have been involved in the contract negotiations at all, or he's just sharing his perspective?
He submitted an affidavit, said he was part of the last discussion. Mr. Robledo, who was the 30B6 rep, who actually was involved in all negotiations, He actually testified as that in his deposition that, let me quote him here. Page 72 of his deposition, he says, as you see on the.
Page what?
Page 72, lines 20 through page 73, line 8. I cite this in my brief. As you see on the bid notes, things weren't completely addressed. That's Mr. Woodletter talking about the bid notes. And his associate, Mr. Hutter, says it was never supposed to be an estimate. Even the document says it was an estimate, these are the bid notes. And Mr. Woodletter agrees that things weren't completely addressed in this document.
And it was Hutter's lawyer who drafted this contract. So if we're thinking about who the author is, it wasn't your client.
And to be fair, Judge, again, unless there's an ambiguity, none of that stuff matters anyway. I mean, when we get into ambiguities, yes, who drafted is a factor, and all these other things come in. But
Hold on one second. Mr. Johnson just disappeared.
Oh,
So we'll be at ease for a moment. I'll go grab one piece of paper while we're waiting for him to come back. Still no Mr. Johnson. All right. When I finish this, let's just try to give that guy a call and see if someone in his office answers. I'm just getting the sentence for this lady who turned herself in.
I'll go ahead.
Okay, thanks. So do you need a file stamped copy or just one printed out? Okay.
I'm back.
All right.
I apologize. I have no idea what that was about. And
Okay. Well, hopefully it doesn't happen again this morning.
God knows, I hope it doesn't.
Give me 1 second to finish this up. Do you need?
Yes.
All right, Mr. Drager, if you want to come on back, please.
Sure.
All right. Are you down in Savannah?
I am, yes.
All right. Hopefully they can maintain system stability down there in Chatham County for the rest of our hearing. So, Mr. Drager, you were in the midst of sort of rebutting Mr. Johnson's arguments about how post-contract signing conduct can be used to clear up what may not have been clear or to amend the contract, or I'm not saying it very artfully. Mr. Johnson says it better, and he'll get a chance to in a little bit. But you told me how Mr. Roblato, the 30B6 representative for Hutter, had said the bid notes weren't all that settled, and then we had to pause.
Right. What I was talking about, Judge, was, again, my position is, I think the law is pretty clear on this, that we don't get into all this post-contract activities if the contract's certain. I've read you the portion of the contract. What I'm really addressing right now are the things where Mr. Johnson's saying, he's trying to, at least in his brief, point out quote unquote uncertainty in this contract. And one of the things he was saying was that, I believe he presented an affidavit of one of his, Mr. Westhutter, who said, you know, nothing in these bid notes says we're just an estimate. You know, that didn't mean that. And I pointed out to you already places where section 3 of the bid notes say it's just an estimate. And I was pointing out also that Mr. Leto, the 30B1, 30B6 rep on the issue of contract negotiations testified. Quote, as you see in the bid notes, things weren't completely resolved. Again, estimates, all estimates. And then, so first they argued that, you know, the first argument as to ambiguity is the word estimate. They said there are different definitions. We discussed that. The next thing they attacked was the language in the bid notes where they, you know, we point out more estimate language. They said it was an estimate. And then the next argument they made, at least in the brief, was that, well, I think counsel states without any cite to any authority that the language in the, you know, the estimate language in the bid notes doesn't say it about paragraph 12, but he says the language in the bid notes regarding estimates, he calls it quote unquote standard contract language in a commercial contract. They don't have they never identified an expert in this case. Counsel says that with any authority. You know, it may or not be. This contract, though, when you read it, four corners of this contract, you got paragraph 12 saying it's just an estimate, and the bid notes agreeing with it. So, I don't think it's there either. And then I guess the last thing they made in the brief is, again, trying to create an ambiguity, is they quoted me. In my brief, I think I said flat fee, you know, paragraph 2 is a flat fee, and it's knocked away with paragraph, and, you know, the counsel said that creates the ambiguity right there. I guess I should have used the words the parties used, Judge. They called paragraph 2 the contract sum. And as I said, the contract sum is just an estimate and will vary. So there were 4 arguments they made, at least in the brief, as to why there's an ambiguity. I don't think any of this hold. I think it's very clear, reading this contract, it's just an estimate. They didn't establish price. Therefore, the contract, null and void. And again, I've already cited your authority. Every case they cite for this argument that they can bring in post-contract activities. Again, it's the Chile case, the Arrow case. They all talk about uncertainty or ambiguity. When the contract's certain, it's done. You cannot resurrect for them. That's our position on the contract, Judge.
All right. Quantum meruit.
Yes, sir. Judge, I've been at this for 40-some years. I've never even thought about filing a summary judgment motion on quantum meruit. I mean, how do you do that?
You just did.
I mean, I did.
Yeah.
And just so you know, in our pleadings, we admitted that plaintiff's entitled to recover in quantum meruit, and we admitted that. However, Judge, the burden is on the plaintiff to present some evidence, admissible evidence on the theory of quantum meruit. And for whatever reason, the plaintiff in this case has chosen to die on the hill of, we can put this contract in evidence. All we have to do prove the value to the plaintiff, to the defendant. And Judge, and they cite case law, and I'd like to go over that a little bit about how courts have used enforceable contracts in the past. You can present a contract to evidence the value of the quantum meruit. None of the cases, Judge, allow a party to use an unenforceable contract. More importantly, an unenforceable contract that was deemed unenforceable because the parties had not come to a firm agreement on price to establish the quantum meruit value. Let me get my briefs here. The line of cases counsel relies upon starts with actually Missouri case. The Service Construction versus Nichols 378 Southwest 2nd 283 at 288, where the court in Missouri said proof of an express contract between the parties affords prima facie evident proof of the value of the services rendered, and as such is properly entered into evidence. That case was cited for the first time by the Carbonera Court. That's the G. Carbonera and Company versus Helms case at 205 Appeals 547. So we start with the Missouri case, talks about an express contract, not an invalid contract, an express contract. Then Carbonera picks up the same language. And Carbonera, and they basically say in three cases, and Carbonera is the main case they cite on this. In Carbonera, there's the employee is a sales rep and was making 5% of total revenues. There was a gap when when the sale was made, there was a gap where the customer could terminate the contract anytime the customer terminates it, no commission, obviously. And then once it goes hard, you get your commission. And the party stipulated or agreed in the record that was, the agreement was 5% of sales. The question was, the employment was terminated during the contingency period. She made the sale, terminated during the contingency period. She argued she was entitled to the money. Trial court, the jury found there wasn't a contract on that. There wasn't a contract about that, and awarded her quantum merit. And she was allowed to present evidence of the actual agreement they had, which was the 5% to support the case. There wasn't anything Carbonera says you can rely on an invalid, unenforceable contract. They also cite the Atlas case at 225 Georgia Appeals 631, where an attorney was allowed to testify based on his contract, the value of his services based on his contract, which is pretty much standard, happens in this court every week. Again, not an unenforceable attorney contract, a contract. And then the last case I cited is this Nextel case, and that's another sales rep case where, again, the parties were able to present evidence of what their standard rates are and what they had done between them in the past. There was no contract found in this case, but they were allowed to testify as to what they've done, usually do what the typical rates are. Nothing says that you can bring in an unenforceable contract, especially in cases about price. I've cited you a case, it's the Langford case. Langford versus Robinson at 272 Appeals 376, another quantum merit case. And there, the court addressed the issue of an invalid contract. Quote from the Court of Appeals, and the trial court concluded correctly that the agreement that includes a promise to reimburse is not a valid contract. Its provisions therefore cannot control. That's right out of the Langford versus Robinson case. And so, Judge, our position is the only evidence they're presenting on value of quantum merit here is the contract. And I don't think it's legitimate, valid evidence to use in a quantum merit case, unenforceable, invalid contract. Only one court has ever addressed that issue. That's the Langford case. But it makes sense, especially in this case. Because A, we're talking about what was the reason it's invalid is because there wasn't a price. Now you want to use that to show the value to the jury. More importantly, in this case, counsel cited in his brief, and it's a correct statement of law, is that the contractor's cost cannot be used to establish value. And he cites that, I've cited as well. It's actually in the Carbonera case, same language. The reason behind that, as the court explained, the Carbonera court explains, is that if you were, as a contractor, allowed to put in your cost, how's that prove value to the plaintiff? I mean, the building falls down next week. It's built over a property line. I mean, just your cost is not evidence of value to the owner. That's exactly what they're trying to do here by putting this contract in, Judge. They rely heavily on the what is it?
So how would you, I mean, what's an example of something that you think would create an issue of material fact as to the value of the services rendered so that the quantum merit claim?
Appraisal. That's the value, the plaintiff's testimony.
Someone comes in and evaluates the work done and confirms it looks like these walls aren't going to fall over, and it's actually built on their unit at the Market District Crabapple, not on someone else's. So this is all of value to Hyde Brewing, and so it looks like that's $200,000 worth of value.
That's one way it's done.
Okay.
That's the way it's typically done, I think. It's just food. And my client can testify as to what the value is. I guess they can testify as to the value, but and I took the 30B6 deposition of the principal of Hutter on this very issue, and he insisted that it's the contract price. So, I mean, if that's the evidence they've got, that's the hill that they've chosen to die on, and there's no legitimate evidence in this case about, you can rely upon. But going back to, I thought I had, but I don't have it with me today. There's a part of the contract, I do have it. Attached to the contract is a proposal. And counsel relies heavily on the proposal in his argument. Again, the proposal was made part of the contract. It's incorporated into the contract. Proposal is a list, 2-page, 3-page list of Mr. Robleto's estimate of what the cost of the job will be on each of these categories. And then with a 9% profit and overhead at the bottom.
Okay, so it's back to contractor costs again.
That's my point, Judge. They're saying this number, this $953,000, I can put this contract into evidence. I'm done with my case. But what they're really doing is to put in the cost, which is what the proposal makes up the fixed sum in paragraph 2. They add it, and they're saying, let us go in and put this document into evidence with the proposal, shows our cost, which they cannot do. Doesn't show value to my client. So for those reasons, Judge, A, it's an invalid contract. B, in this particular case, it's an invalid contract based on price. And C, they're trying to get in the evidence through the back door, which you know they came through the front door, is by putting the contract in, showing their cost, which of course I said repeatedly you cannot do. That's our argument on quantum merit, Judge. The next issue we have is the attorney's fees question. And just as I've never thought I'd have a summary judgment argument on quantum merit, I don't call any court, and so we've both checked, he's checked and I've checked. No court in the state has ever upheld an attorney's fees award, as far as I can find, on when the case is based solely on quantum error. Especially in this case, where we admitted from the outset, he's entitled to quantum error. The only dispute we have is we don't think we owe the exact contract price plus adding on 2 change orders that were never agreed to. We don't know that amount. It's a legitimate dispute. Not to mention that we have this dispute even on the contract. So, I said, well, let's break down the contract, the attorney's fees claims. First, he makes obviously a claim based on the contract terms. The contract has an attorney's fee provision in it. Obviously, if the contract's invalid, the attorney's fee provision goes out the window as well. I don't think there's a serious dispute there. But they now back it up with, making a bad faith attorney's fees claim under 13-611. And again, we've admitted in our pleadings, you're entitled to quantum error. I thought they present some evidence, but they haven't. But at the very least, just because we don't believe we owe the exact amount set forth in that contract, plus the 2 unsigned change or unagreed to change orders, that we're acting in bad faith. There are 2 cases that address attorney's fees in a quantum error case. In both cases, the court rules matter of law that there was no bad faith and no attorney's fees under the statute. And the one is Adair Realty versus T.M. Wellham. That's it. I think it's 141 appeals, 101. It's 1977 case. And the others, Nextel South Corporation versus R.A. Clark Consulting at 266 appeals, 85. They're both cited in the briefs. But in Adair, they sued on contract and quantum error. The contract was knocked out. The defendant moved for a directed verdict on the issue of attorney's fees to close the case. Judge denied it. Jury returned a verdict. Court of Appeals reversed on the attorney's fee, saying it's a legitimate dispute here. Then in Nextel, it was just the opposite. The trial court granted a directed verdict on the issue, on a quantum error case, granted directed verdict on the issue of attorney's fees. Court of Appeals said yes, affirmed it as a matter of law. And the court's language in it there, the mere refusal to pay a disputed claim is not equivalent to stubborn litigiousness and bad faith, nor is it an attempt to cause plaintiff unnecessary trouble and expense to collect his money, which was not definite and certain. And then Nextel is, while issues of stubborn litigiousness are normally for the jury, if there's a bona fide controversy, there cannot be stubborn litigiousness as a matter of law. Bad faith cannot be based on a mere refusal to pay a just debt. That's the law in Georgia. And I think, here, Judge, on a quantum error case, you're certainly not entitled to bad faith attorney's fees. Almost done. The lien argument. The law is very clear on this, Judge, that you have to have, if you're a contractor, you have to have a contract to be eligible for a lien, make a lien. And let's let me walk you through the statute. I cited two cases in my brief and the statute. And let's start with 44-14-361. I'm going to go backward a little bit on this one. This is the statute where it gives certain parties the right to claim a mechanics lien. And paragraph 2 gives to all contractors the right to file materialman's lien. And counsel correctly cites section C of 44-14-361, which says that the lien specified herein be based on an applied contract. What counsel doesn't mention, Judge, is the preceding statute, OCGA 44-14-360, which defines what a contractor is for purposes of bringing a lien claim in Georgia. That statute, section 1 of the statute, defines contractor as a contractor big C is a contractor little c having privity of contract with the owner of real estate. So to get to 361, you have to have a privity of contract, and then you have the right to make a lien claim. There are parties, and 361 is full of trades that can bring certain lien claims without having a contract. A general contractor is not one of them. They have to have a contract by definition. And I cited two cases in my brief that support that statement, as well as the lien foreclosure statute requires you have a contract. So, if you find there was not a contract in this case, it cannot be a lien. And that would go for the plaintiff, for the defendant, as well as the landlord. It's all based on the lien claim. And just one more thing, Judge, it's in our briefs, but I noticed the other night, I was getting ready to prepare for the hearing, they don't have a count, but they have, in their prayer for relief, they ask for interest. Again, you certainly can't get interest on a quantum error case. They have their unliquidated damages. I don't think they have right, even in the contract case, I don't have liquidated damages. But certainly, if this is a quantum error case, you're not entitled to interest on an unliquidated claim. I think I've covered it, Judge. Any questions? Be happy to answer them. Any more questions?
I don't right now, but what I will do is turn back to you after Mr. Johnson goes in case you've got any rebuttal. Mr. Johnson, you ready?
I am, Your Honor, and I apologize for that glitch earlier.
No problem. We're still here.
It's not unusual for attorneys to have all differing views of a case, but one thing is abundantly clear here, and that is that both parties understood and intended that this was a fixed price contract. It's interesting and
tell me how that intent is clear to someone who reads the contract. So let's stay away from parole evidence and look at the four corners of the contract and get me to the abundant clarity that this is a fixed price contract?
Well, of course, it says so in paragraph 2. The if I could, I think that all the facts show that this is just a after the fact effort to revise what this contract meant to these people at the beginning. I mean, if we look at the contract, which is what you've asked me to do,
Yep.
without any of the post-contract conduct, which I do want to argue, by the way, but the section 2 states the price of the services to be performed. It goes on, that section goes on to say, subject to additions and deductions mutually agreed in accordance with section 4. Then section 4 talks about change orders and provides for additional services to be performed, and they get billed separately. So just to get to that discussion of unagreed to change orders, in fact, the testimony of Mr. Dreger's clients was that they did agree to them. And they're to be billed separately as they were. Then section 8 of the contract requires payment by Hyde of invoices for increases in the contract sum due to change orders. If we had something other than a fixed price, there would have to be some term in the contract itself to determine what would get paid. And I know I can hear Mr. Dreger saying, well, yeah, but it's not a real contract, and that's why it's not a real contract, is because there isn't any determination. But these are two parties who are grown adult business people who signed this document with this number in it. If they intended that the proposal, the attached proposal and or the attached bid notes meant nothing, then why sign this document? The testimony that Mr. Dreger's clients have pointed to, whether it's true or not, is that these proposals were always too high, so they never would sign them, and that the 953 was too high. It didn't fit in their budget. Well, what in the heck would these people sign this document for with the number $953,000 in it? It makes no sense whatsoever.
Well, because paragraph 12, let's go there then, because
yeah, the whole focus of the argument here is on the words open estimate. What that does is, and there's a lot of this going on, is taking things out of context.
but when you say things like that, I'm not familiar with case law that says, hey, there's a contract and the four corners of the contract, and if it's not ambiguous and there's a sentence that says the contract sum in paragraph 2 is only an estimate. I didn't add any words. But that's what paragraph 12 says. I'm not familiar with case law that says, but you need to understand the context in which these people were negotiating. That's not what courts are supposed to do. We don't get into context and have one side say, well, we felt pressured to enter this, and the other side say, it was clear to us what this meant. It says what it says, and it says it is only an estimate. Yeah. And I don't understand how you get around that.
Well, here's what I was actually saying is it's out of the context of the rest of the sentence, Judge. I wasn't saying out of context of some extra contractual discussion. What it says is owner and contractor agree that the contract sum in paragraph 2 is only an estimate. That's where Mr. Dreger would like to stop. And then it goes on to say, and will vary based on the actual work performed at the site by contractor in accordance with written instructions from Hyde Brewing during the construction process. And so if we take it all together, that what that sentence says is that the price can change. That's why it's an estimate. And again, and I noticed Mr. Dreger discounted my definitions, but they are definitions of the word, and he didn't dispute that. That say a statement of the cost of work to be done or a statement about how much a job will cost. But but the variance that's subject to the word estimate, or that informs the word estimate, is a variance that's going to be based on a written instruction regarding the scope of the work during the construction process. And that's consistent with all the other provisions, the 3 or 4 other provisions that I went through before getting to paragraph 12. And that's why I went through those, because they set up a consistent explanation that the contract price can in fact change. And as Your Honor noted earlier, it can, of course it can. Mr. Dreger mentioned AIA contracts. I work with AIA contracts all the time. It's the American Institute of Architects contract forms, and they have a variety of them, and all of them provide for potential change to the scope of the work and also to the price. Oh, and just as an aside, the issue of price escalations, steel, tariffs, whatever, it has gotten to be now, because of the uncertainty of prices over the last several years, it's gotten to be fairly common to put an escalation clause, separate escalation clause in these contracts that says if the price is increased by 10% or more on some specific good, that then either one or the other party eats it, or they split it in some manner.
Okay, I appreciate that. And I also appreciate that paragraph 12, it's only one sentence, but there are words that follow the word estimate. But how is it that paragraph 12 means something other than, hey, that number up in paragraph 2, that's an interesting number, but that's not the number. It's not going to be that. It's going to vary. It really depends on what work we do and what Hyde asks us to do. And so really, we don't know what the number is going to be. We did put a number up in 2, but 12 is the acknowledgement that we're really not sure what work will be performed and what Hyde asks us to do. And so your real number will be whatever work we do.
That would be
That's how I read 12, which then says to me, you've got an agreement that we're going to do some work. I don't know what it's going to cost.
It's not that. The only evidence regarding the plans and specifications for this project is that there was a stamped, permitted by the governmental entity, a stamped, sealed, permitted, issued for construction set of plans in place when this contract was entered into. Mr. Dreger wants to point to the bid notes, and he says, well, it says estimate. It says estimate in at least one place, and it says very similar to paragraph 12. And all of those factors taken together, your Honor is familiar with the law of contract interpretation just as well as I am, if not better. You look to enforce all of the provisions of the contract, to interpret it in a manner such that all of the provisions are effective. If $953,981 means nothing, then that is discarding a very important and very specific portion of this contract in favor of an interpretation of a sentence that can be interpreted to be consistent with all of the other provisions of the contract regarding changes.
So I'm going to give you credit for actually knowing a whole lot more about contract law than I do. You've got the experience, you've worked with AIA contracts of many forms, et cetera. How often have you seen something like paragraph 12 in a construction contract?
If it were not for the word estimate, it wouldn't be unusual in any way, shape, or form.
But that word is in there. So how often have you seen a paragraph like paragraph 12 in construction contracts you've had to defend or edit or be embarrassed about or wish didn't exist?
By the way, I want to make clear to everybody in the courtroom and elsewhere, I did not draft it.
No, I know you didn't write this.
This contract was drafted, apparently, according to the testimony, several years ago by a lawyer for Hutter, and they've used it in the past. I don't know how many times. I don't recall any specific testimony on that, but I did not draft it.
Right.
can I say to the court that I've ever seen the words only an estimate in a construction contract? Maybe, but it would only have been directed to one specific portion of the work. In other words, it would say, here's the price for, just pick a percent, 95% of the work, or all the work that we know we're going to be doing, and here's an estimate if you select this. And by the way, that's what the bid notes do. They don't create confusion or reflect estimates. And Mr. Wes Hutter did not just say, oh, they weren't intended to be estimates. What he said was pretty detailed, in fact. What he said was, Hutter provided with each proposal a set of bid notes and clarifications which clarified aspects of the work included in each proposal, summarized changes from prior proposals made at Hyde's request, and noted potential alternatives that Hyde might select during construction. And by the way, Mr. Greger quoted a portion of Mr. Robledo's testimony on that same issue, but left out the rest of it. What Mr. Robledo said in addition was, the conversation was, if there are other changes that could be made, they could be made, and all that conversation would have to be addressed with the project manager after the contract, which is exactly the same setup as any fixed price contract with change order provisions. So the argument that I'm making on the contract itself and its four corners, as we've said, is that unless the contract is read completely as a whole, rather than picking out only an estimate, then we're throwing out, and this is really the argument, is to disregard large portions of what this contract says about there being a price and that there are going to be change orders that may change that price. And that's the only consistent way that I can see to read only an estimate, is to qualify it by the rest of the sentence, which says how the price will change. Now, could Hutter's lawyer 10 years ago have used a better word? Sure. But is that the basis to throw out a contract between these parties that has been fully performed by one of them?
So I guess where I'm struggling is that your argument to me sounds like, Judge, but for paragraph 12, this is such a standard situation. Everyone knew what the terms meant. This is how people do business in this area with the bid notes and the negotiations and their change orders and this and that. And so why would we disrupt what is otherwise a very standard construction agreement because 12 is in there? But 12 is in there and it's a wart and you can't excise it. And so I want to understand your argument in a different way, but what I hear is, look, everything else about this contract is up to snuff and is a standard fixed price contract. And so we need to read 12 in some alternate definition of the word estimate. Shouldn't have put it in there, tough choice of words. And why throw the baby out with the bathwater just because 12 is in there? And the answer isn't the answer because 12 is in there. No. And you haven't encountered this language before. And you were very clear to say, I didn't write it. You were running from paragraph 12, but you can't remove or erase or rewrite paragraph 12. So it's your burden.
No, but I understand that. All right. What I'm saying is not do away with the words only an estimate. What I'm saying is that those words, in order to be interpreted in accordance with the rest of the contract, and specifically including the rest of the sentence in which those words appear, it should be construed to mean what these parties, I do think I need to discuss the fact that post-contract conduct can supply terms to the contract.
Of course you do. That's a big part of your argument.
But I think when you don't take the words only an estimate, whether it's in the contract language or in the bid, it's the same thing. It's the same language basically. But if you don't construe the words only an estimate to mean that the price can vary or may vary, it may not, may vary due to changes made by Hyde. If you don't construe it that way, then all of the other change order provisions mean absolutely nothing. Virtually everything in this contract means nothing. But primarily that sentence then means nothing. What price could vary based on changes made by the owner if there is no price? I mean, we're basically throwing out the whole contract to interpret the words only an estimate in the way that Mr. Dreggers believes is the only way that they can be interpreted. And I think that to enforce all of the provisions, it makes that mean what I'm suggesting to the court that it means.
Okay. Well, let's talk about post-contract conduct and the law you think that authorizes me to consider it, and what that conduct is that you think sheds light on what only an estimate means,
Yeah,
or that it was a fixed price.
there's a lot more to it than what you've heard so far, Judge. And one of the things that I need to do is to make sure. Mr. Dreger talked about the billing, and Your Honor asked questions about percentages of completion. No one on Hyde's side of this case has the expertise upon which to make any estimate of how much this job was complete at any given time. They just say it. None of them have a construction background. None of them give any factual basis. None of them have anything other than a conclusion that they apparently pulled out of thin air. So whatever is said regarding percentages of completion that is not based on Hutter's, because we have people who actually have qualifications at Hutter. Wes Hutter, whose affidavit we submitted in connection with this motion, has a degree from Georgia Southern from their construction management program. He's been managing projects for 8 or 10 years. He's done lots of projects. This is what he does for a living. They submit their pay applications on the entire basis of the payment application starts from the contract price of $953,000. The entire basis of it is that. That number is broken down into separate categories, each of which is attributed a specific value in I call it a schedule of values. I think they used a different term, but it's essentially a schedule of values, which is the third page of the form. Oh, you know what, Judge? I hate to do this, but let me go back a second to the prior argument. Well, I don't need to. I'll do it in the quantum meruit part, but beginning with its first payment application, Hutter submitted for payment on the basis of a fixed price contract, and I haven't heard any argument to the contrary on this. And that application, on the second page of it, the first page is just sort of an invoice. The second page is a breakdown, and it's in a form that is very similar to a standard form, including a standard AIA form. And it shows a breakdown of the amount of the application, and it starts with original contract amount, and it says $953,000. It goes on to talk about the contract sum to date, meaning the contract sum with any changes, additive or deductive changes that may have been made. And in this case, there weren't any approved at the time of some of these pay applications. It wasn't done until it was billed later, which is consistent with the terms of the contract. So that says $953,000, and it specifically says contract sum to date. It shows a current payment due and a balance on the contract. Well, the balance on the contract is the $953,000 less the contract sum, less the current payment due. That's number one. The subsequent ones would include the amounts billed on pay app one. So every single payment application defined the contract sum. Every single payment application applied for an amount owed based on a percentage of completion of that contract sum. Now, if Hyde thought that the contract sum meant nothing, then it certainly would not make any sense whatsoever to pay on the basis of completion a percentage of that contract sum. And that's what they did for months. And in fact, that's what they did until after this dispute arose, and apparently they were unable to pay. There are 4 exhibits in Mr. DePaula's deposition, exhibits 21 through, maybe there are 5, 21 through 25. And they consist of correspondence first between Hyde and Hutter. And in those, and this is after Hutter is demanding that its pay app 5 and subsequently its pay app 6 be paid. By the way, there was a 7th, and that was retainage. There was 10% retainage withheld from each pay application. And what that means is, and it becomes utterly meaningless if there is not a fixed contract sum. How do you get 10% of nothing? It's 10% of the $953,000, and you'll see that pay app 7 is for $95,700 or something in that range. So both parties throughout the project treated this as a fixed price contract for billing and payment purposes. And there's just no way of getting around that. And we haven't heard any argument that there is a way to get around it. Now, I heard the argument that you don't get to look at post-contract conduct, but that's not what I've seen in the law. I quoted a case called Tidwell versus Roca Properties on page 12 of my brief. It says, finally, the subsequent conduct of the parties to an agreement may be considered as evidence of their intent. And as the court is, of course, aware, ascertaining the intent of the parties is the most important aspect of construing an unambiguous contract. And this one, I hear the argument that it's not ambiguous, but it's hard for me to imagine how it cannot be when there's a specific statement of a contract sum in the contract. If it's not ambiguous, then you still look at all of these factors, these post contract factors, in the context of supplying the definiteness that's required. And again, I heard an argument to the contrary on that, but we've cited case law that clearly supports that manner of analysis. And I mean, it just flat out says the determination whether a contract contains the requisite certainty is made at the time enforcement is sought. And I think Your Honor mentioned that early on in your summary early. And it's not accurate to say that it had to be an enforceable contract. There's a difference, and it may be a subtle one, but this contract is express. It's there, it's written, it's signed, it is express. The argument that it's indefinite doesn't change the fact that it's express. If it's indefinite and unenforceable, I don't see why that makes any difference to this analysis. But at any rate, I mean, it can be an unenforceable contract. One of the cases that we cited is Steinemann. It's on page 14 of our brief. It says, and it found a question for the jury on the basis of subsequent performance after noting that lack of definition of a necessary contract term rendered the contract too vague and indefinite to be enforceable. Well, that's pretty clear. And all of this post-contract conduct is in fact a matter that should be considered by the court either as a means to resolve any ambiguity, or if that doesn't fly, then to supply the terms that are necessary so as to make the contract definite at the time it was sought to be enforced. Beyond pay applications, Hyde submitted, and this does involve Mr. Slomka's client, and I'm not sure why they're not a little bit more exercised about this. Hyde submitted documentation to its landlord in connection with its requests for payments of a construction allowance that was provided by the landlord to defray a portion of the build-out costs that Hyde was going to have to pay. And this was done monthly. And Hyde submitted documents that said, right at the top, or maybe it was I shouldn't say at the top, but specifically said the contract sum was $953,981. And they applied the percentage of completion billed by Hutter in its regular progress payment applications. They applied that percentage provided by Hutter to the contract sum of $953,981 and to the total allowance amount. The amount of payments that Hyde received from the owner was based on the percentage of completion of the $953,981. So everything that was done post-contract was establishment of a fixed price contract. And I mentioned the communications, there were text messages and emails after this dispute arose. And there's no mention of, oh, we don't have a contract, or, oh, it was just an estimate. What is said is, we want to discuss some specific items with you that we don't think got done correctly, or something like that. It's not, we didn't have a contract because the word estimate is in the contract. That doesn't happen until the last communication, which is a communication between Hyde and the landlord. And Hyde says, in this email correspondence with the landlord, it says, we think we can get out of this thing, basically, because we think we can say this was only an estimate and we didn't really have a contract. And the reason I bring that up is because that juxtaposed with the evidence that everybody proceeded with this contract on the basis of a fixed price is demonstrative of the fact that this whole theory, and I get it, Judge, you're looking at a contract document and that's what you have to do. But in looking at the post-contract conduct, this demonstrates that this whole theory of, oh, it's just an estimate and there never was a contract in the first place, that never occurred to anybody until after the fact. And it's a construct. And then we go back and we look at the bid notes and say, oh, well, those also are an estimate. Well, they're not. They're an explanation of the work that's going to get done and the possible alternates that might get used if elected after the contract is in place. The whole argument is a manufactured one after the fact. But again, if post contract conduct can be taken into account, which the case law says it can, either in interpretation of an ambiguity or to provide at the time the contract is sought to be enforced the definitiveness required to make it a contract, then that's what we believe the court should do. And I want to make sure that the court is with me on the manner of billing and payment. And because it's important that this was based on scheduled values that add up to the contract sum and then percentages of completion of that work. I cannot think of another explanation for why it would have been billed and paid. Now, Hyde too was involved in this, why it would have been billed and paid that way if everybody didn't believe, intend, and understand fully that ultimately Hyde was going to have to pay $953,000 for this work. And in fact, they collected their tenant allowance on that basis. They even collected their tenant allowance on that basis for pay apps 6 and 7, which are the final less 10% and then the retainage payment application, which add up to the $360,000. They collected that money from the landlord on the basis of those percentages and on the basis of the contract sum, and then they didn't pay it through to Hutter.
So is it correct to say that when the fifth, I'm going to use the wrong term, payout notice was submitted and Hyde paid it, the work was about 2/3 done? Because I think Mr. Drager was saying that gets us to the 600-ish thousand that's been paid out, which would leave the about 360,000 remaining, which says to me, you still have a whole third of the work to be completed.
Well, that's dependent. It's funny because usually owners, which I realize this is a tenant, but the owner in the construction contract context, usually owners complain that contractors bill too much early on in the job and get ahead of their progress. It's odd, very odd for an owner to complain about slow billing. If it's a $953,000 contract, which is regardless of whatever anybody else says, obviously Hutter thought it was, and that's how they build it. If it's $953,000 contract and they don't bill their profit and overhead, say, or a large share of their general conditions costs, or their labor burden, if that stuff doesn't get billed until the end, that's not to the detriment of the owner. The owner's going to have to pay it regardless.
So the fact that the work was more than 60% done, but the billing was only at about 60% is not evidence that it was just an estimate and that the total contract price is probably more like $700,000 or $750,000. It's that Hutter was not an aggressive biller.
Correct. And that, in fact, is part of Wes Hutter's affidavit, in which he says that towards the end of a job, you get Well, that's sort of a separate thing, but toward the end of the job, you got to get everybody back in there to do their finish work. The plumbers, the electricians, they got to do all their finish work and they're all over each other and you got a lot of people in there. So you typically end up billing a lot on the last payment application. But also Bruce Hutter, who is Wes's father and the owner, basically, to use a layman's term, the owner of the company, he testified in his deposition that that he will bill what he feels he needs to cover what he's spending along the way, and he may not bill his profit and overhead and all that kind of thing until the end. So it's another aspect of going back and looking at things from a rear view perspective to try to make it fit an argument that there wasn't a fixed price. And again, I understand you're going to look at the contract, that's what you do, but from the pure standpoint of what these people were doing and thinking and intended and understood, there isn't any question in my mind, and the evidence is clear as day based on the post-contract conduct, that they knew they knew they were going to pay $953,000. If they didn't submit $953,000 as the contract price to the owner, and the percentages of completion along the way, when they got down to the end, if they'd have said to the owner, oh, we're only going to spend 650 or 750 or whatever they might come up with at this stage of the game, then the owner would have said, okay, well, then you don't get the rest of the allowance, because what they were paying was a percentage of the overall construction sum. There's just not a real way around that. So the options are to throw this thing out altogether, or to enforce it on the basis of what everybody understood it really was. I do want to make, I think we've got some confusion here about cost versus price. The contractor's cost, and I think, I don't want to put words in his mouth, but I think Mr. Dreger said that the proposal shows Hutter's cost. It doesn't. It's the price to the owner, which obviously includes a lot of things other than cost, including overhead profit. It includes labor burden, which is all of the things that you spend on a employee that are in addition to what the employee actually receives in payment. Real briefly, my understanding of the law, and I can be corrected, is that a jury can award interest on unliquidated damages if they choose to do so. It's not automatic, but they can. Now, I guess if you don't have any questions for me any more than you've already asked, I guess I'll move on to the quantum meruit aspect.
Let's do that.
Okay. Well, first, and the only thing again, and I think this is acknowledged by Mr. Dreger, is that there was work performed, it was accepted, and Hutter is entitled to a quantum meruit recovery. I think the only argument is that ostensibly there's only one element of proof of those damages, which is entirely inaccurate. And then in reliance on this Langford case, and I saw this brief come in this morning, I thought that Your Honor didn't allow reply briefs without permission, but
I don't, and it came late, so that's 2 strikes against it. So you're welcome to talk about it. I have not laid eyes on it.
Well, Mr. Dreger did bring up this Langford case, though, in his argument, so I'll respond to that. And that was in the context of his contention that the stated contract price can't be used as proof of value in the quantum meruit context. I just think that's not the case, and we cited our.
I thought what he said was that if it's an invalid contract. If the contract is something everyone agreed to and it doesn't have paragraph 12 in it, then there's your lodestar. Everyone agreed this is $1 million project. And the project's done now, and Hyde only paid $300,000. Then you can use that $1 million as the lodestar. But we don't have that here, arguably. That is Hyde's perspective, because it was only an estimate, and you can't use an estimate to say, all right, that's the value of the work we did.
Well, I didn't hear the argument that because it was quote unquote only an estimate, you can't use it. The argument that I heard was that because the contract was unenforceable due to indefiniteness, therefore you couldn't use it. But
okay, we're saying the same thing. I agree. That's what I heard.
okay, well, and again, I'll point back to that Steinemann case that found a question for the jury on the basis of subsequent performance, all these things that we're saying that went on after, and noting that a lack of definition of a necessary contract term rendered the contract too vague and indefinite to be enforced. And other cases that we've cited in our brief. And that Mr. Dreger tried to distinguish. The Center Point case, I think, is a good one. And it says, it found, this is on page 18, it found that a commission calculated based on an agreement that was sent to the defendant was prima facie proof of value, even though the contract claim was rejected by the jury. So the jury found in that case that the contract claim, because if I remember the case facts correctly, and I think I do, the defendant sent a contract, but the plaintiff didn't sign it. Excuse me, the plaintiff sent an agreement, a draft agreement to the defendant. The defendant didn't sign it, so the jury found there was no contract, which is, that's the same argument that we're getting here. There is no contract. But the fact that that was the price stated in that contract was sufficient to create as prima facie proof of value. The service construction case, proof of the express contract between the parties affords prima facie proof of the value. There's another one at Atlas Automotive where it was a quantum meruit claim, but because there was a written contract out there, it was sufficient proof.
Right, but Mr. Drager referenced all those and said in each of those there was a valid contract, and of course his position here is there isn't.
There wasn't. Certainly in the Center Point case, the contract claim was rejected by the jury.
Okay.
The other thing is, and I did that same case, that Center Point case, says that proof of value can be by circumstantial, inferential, direct, or positive proof. Just about anything is basically the way I read that, and that's exactly what the case says. I believe, and obviously you're the one that's got to make the decision, but I believe if you sign a contract that says the price of the services to be performed and materials to be provided by contractor on the project is $953,981. That's certainly circumstantial or inferential proof that you felt like that was a relative value of that work to you. But here's the thing: there are other aspects of the evidence in this case that prove the value to Hyde. Hyde took out builder's risk insurance. And it did so by telling the agent from whom it obtained the builder's risk insurance, and this is a quote, from an email from Mr. DePaula of Hyde. It said, quote, build out cost, and then in parentheses, without equipment, $1 million. And I asked Mr. DePaula the obvious question. You wouldn't get coverage limits higher than what you felt you needed to cover your build out costs, would you? And of course he said, no, you wouldn't do that because you'd have to pay more for it. Well, that's certainly circumstantial or inferential, if not direct and positive proof of what Hyde thought the value of the work was. There's the court, again, I won't go back through all of it, but the course of dealing with the billings and the payments, you're being billed on a percentage of completion. You know that ultimately that percentage has to get to 100%. You know from pay app 1 through 2, 3, 4, 5, 6, 7, and retainage, you know that you're going to be billed for, and you're in the process throughout the project of paying for $953,810 or whatever that number is. If they didn't think it was worth that value to them, then why were they paying on the basis of $953,000, which they did over and over and over again? Again, that's proof. The applications to the owner, which I talked about earlier, they specifically used the contract sum. They knew that, and Mr. DePaula testified to this too, that he knew that he was going to have to bill out the whole 953 or get billed the whole 953 in order to bill his owner for its share of the construction allowance. And in fact, of the contract sum, and that's what it says in those submissions. So we're here on summary judgment motion, and if there are facts that tend to prove our quantum meruit value, then there's no summary judgment. All of those facts, and again, I obviously have a disagreement with Mr. Dreger over the law with regard to the contract price. The fact that there isn't a case where he says there isn't a case where there was an invalid contract, I think there is, but he says there isn't a case to that effect. That doesn't change the fact that when somebody signs a document that says $953,981, that ought to be at least enough to get to a jury on what they thought this was going to be worth. And had they made no changes, then it still would have been $953,910. It would have stayed right there. And that's in the terms of the document itself. So why shouldn't that be proof of what they thought the value was to them? At any rate, there's plenty of proof of value. It can be proven in just about any way, shape, or form because it's a difficult thing to prove. It just is. The Langford case that is ostensibly contrary. In Langford, this was a tenant who did a bunch of property improvements to the rented property, and he then sued a deceased homeowner's daughter and the deceased homeowner's estate, and for in quantum meruit for the value of the work that he had performed. And what this case, there was no actual agreement. The tenant prepared a rental agreement. The daughter never signed it. And then there was a separate agreement. And I don't know if this one was even, well, it was executed. The second agreement was for him to make some improvements to the house. No definition whatsoever. You can make improvements while you're in there. is basically the way I'm reading this. The issue became not the value or the amount of damages for quantum meruit. The issue became which of the two defendants, the daughter or the estate, should have to pay for it. Because by the time the administrator had not been appointed at the time that the work began. But what the court discussed and what it ruled on, not anything to do with value, was the daughter's argument that the improvements were performed for the benefit of the estate, and the court agreed with her. And that's where the quote that in this that Mr. Dreger relies on comes is in that context, contrary to Robinson's the daughter's argument. Excuse me, contrary to the tenant's argument, whether the repairs were made primarily before the administrator was appointed, whether Langford alone signed the document purporting to reimburse her, not controlling issues. The timing of the improvements is immaterial if a benefit was bestowed upon the recipient. And the trial court concluded correctly that the agreement that includes the promise to reimburse is not a valid contract. Its provisions, therefore, cannot control. It's not talking about value at all. There's nothing in that case that discusses value other than to say that there was evidence for the jury and that what the jury decided as the value was within the range of the evidence. There's no discussion of whether there was because there wasn't a contract. There was nothing in the document that said what the price was. So it's got nothing to do with our current case. It doesn't change my analysis in any way, shape, or form. Attorney's fees, I mean, obviously they're in the contract. So if the contract is enforced per our arguments, then attorney's fees are contractual. We do have a OCGA 13611 bad faith claim. The only issue as to quantum meruit, as we've said and as has been acknowledged, is the value. Hyde has provided no evidence of value, none. They tried to do an analysis based on cost, but as Mr. Dreger now acknowledges, cost is not relevant to the value to the defendant. So we have the proof that I've just discussed, which is 4 different items of proof of value to Hyde versus nothing. And I think that should be more than sufficient to get a bad faith attorney's fee claim to a jury. It may not survive, but it should get to a jury. Add to that the correspondence that I discussed earlier that, to my mind, reflects that this whole argument arose only after the fact and was created after the fact. I think that the attorney's fees under 13611 should get to a jury. On the lien claim, which I guess is the last thing here, 44-14-361, and Mr. Dreger read it to the court, says, and I'm going to edit it a little bit, but to save time, each special lien specified shall, in subsection A, by the way, refers back to the subsection that Mr. Dreger relies on to define a contractor. Each special lien specified in subsection A shall include the amount due and owing the lien claimant under the terms of its express or implied contract. And then I've cited case law. I've cited the book on construction liens in Georgia by oh gosh, what's his name? Dan Hinkle. Cited some case law. Quantum meruit is in essence an implied contract claim. A lien is expressly authorized by the statute. Mr. Dreger seems to argue that because the definition of contractor and I don't have the specific language in front of me, but the definition of contractor is somebody with privity with the owner. Well, if you have an implied, what I didn't see is any citation to any law that says an implied contract does not create privity with the owner. If you have an implied contract, therefore a quantum meruit claim, you got to have a contract with somebody. And I'd suggest that's with Hyde in this case. Lien rights are established against the landlord on the basis of the tenant allowance contribution, and that's pretty straightforward law on construction liens in this context.
So do you have what's your view on case law as opposed to interpreting the statute for a quantum meruit claim based on an implied contract being sufficient to support the maintenance of the lien?
Well, the cases that were cited, and they're the same ones that were cited in the brief that was filed at 8:04 this morning. What they were cited for in Hyde's original brief is that the lien statutes are in derogation of common law and must be strictly construed in favor of the owner and against the lien claimant. They weren't cited for the proposition that there is case law that says there can be no liens for quantum meruit claims. So I know of no case law to that effect.
Okay, so it's just interpreting the statute is what we're working through.
Well, I think the statute is express.
Mm-hmm.
I don't think it requires any interpretation.
Okay.
And unless we throw out implied contract along with only an estimate.
Right. Okay. Anything else?
No, sir.
All right. Mr. Drager, any rebuttal?
Judge, as I'm sure you've never heard before, only a few statements.
Only briefly.
Only briefly.
All right.
Let me work back. Well, no. Start with the contract. I didn't hear, the case law is very clear that before you get into all this stuff about post-contract, you have to have an ambiguity, uncertainty. It's in counsel's brief. He talks about Georgia law does not favor destruction of contracts on grounds of uncertainty, such as indefinite contract may require more precision and become enforceable because of subsequent words or actions of the parties. Judge, if this contract did not have paragraph 12 and didn't have paragraph 2, then there'd be uncertainty. And I think you could use, obviously they're building a building, is it applied, it implies somebody's going to pay somebody. Then yeah, let's figure out what they agreed to. I think arguably you could make that argument if those two paragraphs weren't in there. Here they have it. Here's a number. It's just an estimate. It's an agreement to agree in the future. And I'm not relying on just the word estimate. I'm relying on the word just only an estimate. And the price will vary depending on work actually done. They're saying we'll agree in the future. So you can't get to all the stuff, all these allegedly bad acts he throws on my client after the fact. You have to go, you can't resurrect the contract for it.
So I don't think, just so we're clear, I didn't hear Mr. Johnson describing bad acts. I heard him describing things your client did that are consistent with someone who thinks there is a fixed contract price. That's not a bad act. That's just what he wants everyone to cling to. Look, everyone understood this contract to mean it's a fixed price contract. And you're saying they may have thought that, but that's not what the contract said. So I didn't hear him say that Hyde Brewing was trying to poison the workers there or anything like that. It's just, look, when they turn to Mr. Slomka's client to say, we're ready for our construction allowance, They said, by the way, we've got this contract, $953,000, and it's a quarter of the way through. So let's get a quarter of whatever the arrangement is for the construction allowance. To me, that's not a bad act. That's just evidence that maybe your client viewed the contract a little differently than the way you're articulating it now. Not a bad act, just course of conduct, but I don't disagree with your observation, which is the very first one, which is you don't look at course of conduct, you don't look at other aspects if within the four corners of the document there's no ambiguity. Now, that doesn't resolve the quantum merit issue, but I follow you. I just don't want anyone leaving here thinking that the judge thought one side was doing bad things. That's not what I think this case is about.
I will say that on this post-judgment, post-contract action they're getting into, what he accused my client of is every pay app said contract sum, contract sum, contract sum. We submitted to the landlord. We said contract sum. The term defined in the contract as the estimate. So, I mean, it is what it is.
I got it.
But anyway, we kicked this horse to death as far as the contract. I didn't hear any argument as to how it's in any way ambiguous and how you can use post.
Okay, but on the quantum merit side, of course, the question before me is not, do they win? It's, is there a sufficient question of fact that a jury or a bench trial would work through what is the value of the services that were provided that haven't been paid for? And while Mr. Johnson pointed to things that go back to the 953, it still seems like it's some evidence such that this question about quantum merit ought to be handed off to the ultimate fact finder.
If, as they said it in their deposition, the sole basis for quantum merit is this contract, that's not a valid evidence. And that's what we're going back and forth on these case law. Every case that he cited, there was no question of a valid contract. You know, they're all valid, they all contracts.
But let's assume that for purposes of our discussion here, that I find that it's not a valid contract because there was a missing term that's an important term, and so it was an agreement to agree. So there's not a contract. But now we're talking about what's the value of the services performed. All the things Mr. Johnson pointed to, your client turning to Mr. Slomka's client saying, hey, look what's going on here, the insurance coverage they got, those are all markers of some estimate of value such that it seems like a fact finder would have something to wrestle with. In other words, there's not an absence of evidence as to the value of the work that was done. Not the cost to the contractor, but the value to your client. I need $1 million in construction coverage. Hey, Market District Crabapple, time for another payout because look, here's what we've been doing and it's worth more and more to us. We've been spending this. So those don't depend on the existence of a valid contract.
On the insurance issue, of course, Judge, that was in July of 2023, 6 months before the work was done. When he went outside. Maybe the insurance they got after the work would be more the point. But the insurance you got in July of 20, it's not even, it's an email in July of 23 saying this is what we think is going to be done. And by the way, the testimony was it wasn't just for the build out. There was other work that they didn't do, such as installing walk-in freezers, installing the hoods, I mean, the oven work and all the stuff you need. That was all in that number as well.
Okay, so there's more that went into the $1 million than just Hutter's work.
Yes, sir.
Okay.
And
But again, doesn't that just get us into questions of fact?
that issue, I mean, okay, maybe.
Okay, all right, maybe.
Okay, but the point being is the testimony from the witness, what do you base your value on? The contract. They want to throw the contract in front of the jury and say, this is it.
Okay.
And by the way, Judge, again, the contract, the number in that contract, the 953, it's real important, was based on that proposal, which is attached to the contract. And counsel says, he told you that they weren't costs, they were our
Prices.
price. That's not what the witness said. Mr. Rebuttal again testified that every item on that, on the proposal was a statement of their expenses, not price. You add up, lumber, this, that was their cost for each item. And then at the bottom, they threw the profit and overhead. So right there, they're doing just what they say you can't do, which is throw the costs at the jury and say, by item, these are our costs. And it's worse yet, it's not even cost, it's estimated cost.
But are we not saying the same thing if maybe it's cost to get the lumber and the cement, et cetera, but if then at the bottom, there's the profit, labor expense, et cetera, and the final number is what they think the value to them is of the contract, don't you get there? I mean, you
Not by
could,
throwing that contract at him and not by throwing that proposal at him. I mean, they want to come in and say, we think, the value to the plaintiff, to the defendant is X dollars. They can't rely on the contract. They can't rely on this list of cost. And the testament was their expenses. I can give you a quote here. That's case law. They cited on that proposal. So maybe at most they've got the bills of risk policy taken out 3 months, 2 months before the work was started, but rely on the contract, rely on the proposal, which is a list of costs. And the case law is pretty clear, you can't do that. And I've yet to see a case where it says you can use an invalid contract for that purpose. Train of thought. On the lien issue, Judge, again, counsel said I cite these cases at the brief file 8 o'clock this morning. The cases I cited in the brief this morning, the same case I cited previously, and they stand for the proposition that you have to have a contract to have quantum merit. To have a contract to have a lien, you can't base it on quantum merit. 2 cases right on point. EMG Construction v. Beacon Sales. Beacon Sales. I have a Southeast site. Oh, yeah, it's 908 Southeast 2nd, 690. It's a very recent case. It's not a Court of Appeals site yet. And then the East Side Recovery LLC versus Calhoun 368, Appeals 385. Both stand for what the statute says. And one thing counsel and I actually agree on is the statute is very clear. He's just not reading the right, he's reading 361, but 360 defines what a contractor is. And he tries to get around that by saying privity of the owner. It says you have to be in privity of contract of the owner. Per the statute, we're the owner. We own the lease. It's not what we're trying to, you have to have a contract, whether it's me or him, you have to have a contract with somebody. Whether it be they just don't have in this case. So, we don't agree on much, but we agree that statute is very clear. You have to be a contractor, you have to have a contract. And that's what these 2 cases say. And that's what I said in my brief, my first brief and my second brief. Anyway, so yeah, Judge, quantum merit, to me, is the hardest issue we have here. And it's because quantum merit is quantum merit. It's such a, vague kind of concept. Yeah.
Yep.
But they have to have valid evidence of quantum merit. And I guess the best evidence they have is that email change from 3 months before the contract saying we're getting insurance. And fact question becomes why? How much were they looking at? I guess it's a fact question. Is it a fact question? My client testified that the insurance covered things beyond just your number here. So, and as far as there's no evidence to dispute that. So maybe there's not. I don't think there is a fact question. But they cannot rely on an invalid contract to establish it, and they can't rely on a price list, a cost list is what the thing is to establish it, which they testified that that's what it was. That's all I've got, Judge.
got it. Appreciate it. So, Mr. Johnson, there's no sir rebuttal, but I am going to ask you a question that maybe you can help clear up. Mr. Drager just described the proposal, and the words keep changing, not because of him, but people are referring to it differently. I I don't know if it was the estimate, whatever the proposal was from your client saying, here's what it's going to cost, as in what it will cost you, Hyde Brewing. In other words, these are our prices. But Mr. Drager is saying that Robledo said, actually, those are our costs, not our prices. And so you guys are describing, I think, the same document in different ways, and that leaves me confused, and that's a less good scenario.
Yeah, I cannot look you in the eye virtually and say he didn't say that somewhere along the line, but it is a proposal. It then got into the contract as the contract sum. In other words, the price, whether enforceable or not, there it is. This is what you're going to have to pay. If he stumbled and used the word cost, then he did. I would have to go back and look at the word index and see. I certainly don't recall it, but I can't say that didn't happen. I don't hear a cite, so I'm not sure where to look for that. But
Where do I find the proposal or whatever these pages are? The contract is attached as Exhibit A to the complaint. So I got that. But the Exhibit B, now we're getting into lawyers writing to each other saying your client's bad. Where are where's the proposal? I'm happy to hear from either lawyer. Just tell me where.
I believe that a copy of the proposal
It's
is
attached to the contract that wasn't attached to.
Okay, but the contract that's attached to the complaint is just the contract.
But the one that was identified in the deposition, I believe, has a proposal attached to it.
Okay, so which deposition?
It would be,
Mr. DePaula's?
yeah, Mr. Powell's, Finn Exhibit 1.
Okay. Oh, here we go. Okay, so it's listed as plaintiff's Exhibit 1, but that's our contract. There's paragraph 12.
I'm sorry, I was referring to Mr. Robledo.
Oh, okay, but it's also DePaula, and then there is a proposal. It's dated August 18th, 2023, and it lists things that add up to $953,000.
And Jeff, can I give you the cite for that statement?
Sure.
Deposition? It's page 59 of Mr. Robledo's deposition, lines 12 through 18.
But if we look together at the proposal, what you're saying is, just to take an example, item 2 is demolition exterior. It's just about $12,000. I'm going to start with you, Mr. Johnson. Is that the price to do the demolition? I don't care about what someone said in the deposition. Is your understanding of this proposal that $12,000 is the price to do the demolition, or it's the cost, and if you go way down at the bottom, there's overhead, and that's where they bake in their profit?
Well, it is absolutely a component of the price, a component of the $953,000 contract sum stated in the contract. There's no getting around that. Again, if Mr. Robledo made a slip in his deposition, then he did. But I mean, it's a proposal. You don't propose your costs.
No, I understand. I mean, the way I look at this proposal, this 2-page document, is that basically says, hey, we'll do all these things we've discussed, and it's going to cost you, Hyde Brewing, $954,000. And it may be that fire extinguishers are listed at cost at $1,100, but there's overhead. And so that bakes in the profit for Hutter.
Well, there are also other costs that go into all of those things. Hutter had superintendents on the project. They had laborers on the project. You pay your people, but then you also have additional. And I don't know if you're familiar with the concept of labor burden. It's in every contractor adds that into their proposals because they have to pay for it. They have to pay for For workers' comp insurance, they have to pay for general liability insurance, and it's a factor. And I don't want to testify, but it's a big factor because it increases your labor cost, or it's an inherent aspect of your labor costs that if you were solely saying, "Here's my cost," then that's what it would, that it wouldn't include that.
Okay.
It's more I guess what I'm saying, Judge, is it's more complicated than that.
Well, I was just trying to keep it simple because demolition, that actually requires labor. But if we go to item 10, I don't really know how these are numbered because then it jumps to 15. But item 10, specialties, fire extinguishers, $1,100. It sounds like Mr. Robledo may have said, that's our cost to get you 4 fire extinguishers. But then the response to that would be, okay, so what? Because we include the overhead, which may include labor burden, all these other things. Ultimately, the price to the consumer being Hyde Brewing, for Hutter to do all this work, which includes providing some fire extinguishers, is $954,000.
I think
Got it,
that's
right?
right.
Okay. What would you say to that, Mr. Drager?
Mine's a lot simpler, Judge. The testimony, he claims Mr. Roberto made a slip of the tongue. It wasn't a slip of the tongue. The math works out that these numbers are their cost. And they built the profit and overhead as a separate line item down the line.
I see it.
Okay?
Okay.
And he talks about all the stuff about laborers. That's all contained in their costs for the general conditions. There's a whole section document in the evidence of their actual cost.
Okay.
And Mr. Hutter testified that the job cost journal is a reflection of their actual costs, which track these numbers. The whole idea was these are our actual costs.
Yep.
We're adding, including general conditions, our actual cost.
I see it.
Then the profit and overhead. So the price to me is their cost, each of these items, plus the profit and overhead.
Yep.
So I mean, it is their cost.
But in the end, it's the price.
Well, we established, we had a long conversation, it's not the price, it's an estimate, but that's how they come to the price is they take all these costs and add them up.
Got
And
it.
he wants to throw those costs to the jury and say, these are our costs.
Okay.
And I may add, Your Honor, that, this thing about, we have plenty of, I don't know if you want to get into what we had to say about our defense on quantum merit. I mean, I'm not here to, because I've got a position on quantum merit as far as what we believe the value should be.
Okay.
And they know that. And
Got it.
okay.
Okay. I think that's it from Hutter and Hyde. Mr. Slomka is standing and raising his hand in case I miss one or the other. Was there something you wanted to add on behalf of your client?
Yes, Your Honor, very briefly, if I could. Thank you. May it please record the Howard Slumka on behalf of the owner who has sort of been watching this case from the balcony. If your honor were to rule that there were in favor of defendant and that there were no contract, I want to make sure that the order includes a dissolution of the lien. That is the only reason my client is in the balcony. With regard to some things that have come up in the argument, I think it's clear that if there's no contract, there's no lien. But the question has come up, well, what if it's quantum meruit? Is there a lien? And Mr. Johnson spoke to that. I just would point your honor to the case of Lane Supply versus Ferguson, which is at 286 Georgia App 512. That case holds that there is a lien, but it's an equitable lien and only an equitable lien. And it's only present if the owner has acted inequitably and in bad faith. And in this case, we're just watching. No, the plaintiff has not alleged that we have withheld funds. In fact, to the contrary, on several occasions, Mr. Johnson has noted that the landowner, the landlord, has actually spent its own funds on this in the form of tenant improvement. And it's important, Your Honor, because we never paid his client. We have no contract with his client. We have no privity. And there is also Georgia case law that makes it clear that in the absence of privity of contract between the landowner and the contractor, the lien would be improper. And I would point you to Corley versus Northwinds there, which is at 552 Southeast 2nd, 131. Every time that Mr. Johnson properly stated that we paid the tenant, he was saying that it somehow proved what the work was worth or what the quantum meruit number was, but it actually proves that a lien on the property is improper.
It may do both. It may do both. He also was quick to add that it didn't seem like Hyde passed the money on to Hutter. They'd squeeze it out of your client and spend it on something else, but not pay Hutter.
Right.
At least towards the end.
Which may mean, Your Honor, that my client would have a claim against Hyde, but it certainly does not mean that Hutter has a claim against my client who owns a building.
Yep.
All right. I just wanted to make sure that you were aware of that.
Okay.
Thank you, Your Honor.
You're welcome.
And thank you to both gentlemen. I appreciate it.
All right.
Thank you. Your Honor, I just had 2 cases cited to me on this that I had never heard from anybody about. It's not really, I don't think, particularly fair for me to be put in a position where Mr. Slomka is citing case law to me that I haven't had a chance to even.
Well, I'll tell you what, Mr. Johnson, I will let you look up those cases, and if you think they don't stand for the proposition Mr. Slomka says they stand for, then you ought to shoot Ms. Niles an email, obviously copy the other 2 lawyers in the mix, and we'll consider your either counter citations or your explanation for what you think those 2 cases stand for. I haven't read them either. They were just recommended to me, but I will add that Mr. Slomka's position that he's taking seems very reasonable. His client doesn't have a whole lot to do with all the machinations between Hutter and Hyde Brewing, and it struck me as a little peculiar that Market District's property could be encumbered based on a dispute that doesn't involve Market District. And so I'm open to that line of thought and that equitable principle. So I will look at those 2 cases as well. But I didn't hear Mr. Slomka saying, and because of those cases, Hyde wins or Hyde loses. It is simply maybe Market District shouldn't have to be in this mix.
Could I ask Mr. Slomka to email me those citations? I got one of them, I think, but I didn't get the other one down.
Let's email them to everyone, just so I wrote some numbers down, but I often write down the wrong ones, and I'm like, I can't find. This is a criminal case. It's not the one he meant to cite. So State versus Smith isn't the case he meant. So Mr. Slomka can send those to all of us.
Great.
I'd be happy to. Thank you.
Great. All right. That's it. Thank you, everyone. Let me tell you how this will play out. I'm going to take this under advisement. If to me, it's pretty clear how it's going to play out, I may have Ms. Niles reach out to one of you, not named Slomka, to draft an order that says, here's the outcome. The other side will have a chance to review that, not to change the outcome, but to say, wait, no, those weren't quite the facts, or you spelled my name wrong, or something like that. If it's sufficiently messy, then I'll keep it, and Ms. Niles and I will sort out what the order is. But we do want to get something out so that this case can continue to move forward. Mr. Johnson, anything else procedurally?
No, sir.
Mr. Drager?
John, I'd ask you to consider the brief. It's a 4-page brief, 5-page brief that I submitted this morning.
Oh, this morning's brief? Okay, I'll think about what I'm going to do on that one.
I think I covered the argument anyway, but.
Okay, sounds good. And it sounds like some of the cases were in your earlier brief anyway. Good. All right. That's it. Thank you, gentlemen.
Thank you.
Thank you.